We now resume our meeting and we will now commence the procedure of the clause-by-clause examination of the bill. If members agree, we will first examine the Chinese version of the bill. Upon completion of the examination of the Chinese version, I will ask the legal advisor to confirm whether the English text of the bill is appropriate. Members may refer to the Chinese version of the bill set out in today's agenda. I will invite the administration to explain the clauses one by one, and during the clause-by-clause scrutiny, the legal advisor will also draw members' attention to the clauses that require attention. If a member wishes to ask questions on a particular clause, he or she may indicate by pressing the request to speak button when the administration is explaining that clause. I now invite the administration to explain or to scrutinize the clauses one by one. Thank you. Huanggang Port, Hong Kong Port Area Bill, as the Secretary said, we have been using the Shenzhen Bay Port for many years, and we have adopted the same model in the ordinance. There are a few provisions to the bill to declare certain areas at the Huanggang Port in the Chinese mainland as Hong Kong Port Area. Second, to provide for the application of the laws of Hong Kong in the Hong Kong Port Area and providing for the Hong Kong Court's jurisdiction in this connection. Third, extending the territorial limits of certain pre-existing rights and obligations to include the HKPA. And fourth, making provisions to assist in the construction of certain future documents and court orders. And fifth, to set out legislation in relation to that. First of all, we would see the preamble. The preamble sets out the background to the bill. First, the 23rd meeting of the Standing Committee of the 14th National People's Congress on June 26 of this year set out a decision, and on July 8th of this year, it is decided to give authorization to the HKSAR to exercise the day on which the Hong Kong Port Area could come into use. Mr. Kenneth Falk, thank you. I'd just like to ask about a detail. Just now you said that this bill is based on the Shenzhen Bay Court. Here it seems that the area here is Huanggang Port, Hong Kong Port Area and related extended areas. However, when I look at the Shenzhen Bay Port one, it just said Shenzhen Bay Hong Kong Port. I want to understand the definition of related extended areas. Which part are you referring to? Because to me, the bridge behind the Shenzhen Bay Port should also be considered an extended area. Well, if you are to include the related extended areas, should you clarify this in the definitions? I just want to clarify this because in part 2, section 3, it just said Huanggang Port, Hong Kong Port Area, and extended area is not included. Can you try to make this more consistent? Ms. Cho, thank you. Currently, we use Huanggang Port, Hong Kong Port Area and related extended areas, which is what the Standing Committee has been using. If you look at the definition, you can see very clearly which areas would be under Hong Kong rule. That include the areas, the deck of the Shenzhen section of the Lok Ma Chau Bridge connecting the port, the bridge connecting to the interior of the bridge box girdles. At that time, we only used Hong Kong Port Area as the term, and we didn't state out the extended area. But this time, we added in extended area due to being consistent with the terminology used by the Standing Committee. In Section 3, we will make clear Hong Kong Port area. And we have also included the extended areas, and if you look at it together with the annex, you would see the very specific coordinates, so you do not have to worry about us being unclear. I can tell you how we can look at this when we go to that specific section. Legal advisor. I would like to add one point. As Ms. Choi said, when we move to Section 3 and Annex 1, then we will see very clearly the delineation of the specified area. And there's a definition of Hong Kong Port area stating that it means the areas declared as the Huanggang Port, Hong Kong Port area, and related extended areas by Section 3. And because of this definition, when we talk about Hong Kong Port area, it would include all the areas in the port area and the related extended areas. So when we go on to Section 1 and Section 3 and Annex 1, then I'm sure it will be more clearer to members. Ms. Carmen Ken. Ms. Choi talked about the full jurisdiction. I want to understand what it means because it is not included in the bill. I want to make sure that I'm understanding it correctly. That under this bill, upon the passage of the bill, then it would be clear that Hong Kong laws would be applicable to the port area. There would not be any cross-boundary law enforcement. Thank you. Ms. Choi. Thank you, Chairman, and thank you for the question. A member is correct. In the Hong Kong port area, the laws of Hong Kong apply fully, and Hong Kong laws has full jurisdiction. We can also compare it to the XRL at West Kowloon. The border of the mainland is actually situated within the city center. So for the management of public facilities, then it will still go under the laws of Hong Kong. But this time in Huanggang port area, there is no need to manage this, and therefore Hong Kong will have full jurisdiction.
Mr. Andrew Lam. Thank you, Chairman. In 2A, we use the term as a port area and a related extended area. In 2B, we are talking about the area of jurisdiction, including 4 of them. If you look at 2D, from out, it says that the term of the lease is to commence on the day of which the relevant areas are commissioned and the zoning cannot be changed. Is it referring to the 2D because the terminology is the same? Or are you referring to 2A? Thank you, Chairman. Deputy PS. I think we have to look at 2A and B together. In 2A, we are talking about the related extended area. And in 2B, we have stipulated 4 different parts. That is what is included in Hong Kong port area and related extended area. By not changing the aforesaid function refers to both 2A and B, because in point 2B 234 we are referring to the bridge and road. As for the Hong Kong port area, its purpose is to function as a control point, that is, as a port. Understand? Next, Mr. Lam Chen Sing. Thank you, Chairman. Similar to Mr. Kenneth Falk, I spotted that in more than one locations because in part 2 or clause 3, you are also mentioning Huanggang Port, Hong Kong Port area and related extended area. The bill is different from that of Shenzhen One Port and Hong Kong Port area. Other provisions are the same, including part 2 and 3, even the locations. But in the Shenzhen Bay bill, they did not mention about the related extended area. Just now, the administration has responded by saying that it is basically in line with the official reply of the State Council. I just want to understand why is there the mentioning of the related extended area. I just want to make sure that the two ports are actually quite similar. Why is it mentioning the related extended area only here? Asked and answered already. Yes, as mentioned, the terminology that we use this time is referring to the authorization of the National People's Congress. As the legal advisor mentioned in interpretation and in clause 3, I will further explain the terminology of the provisions is referring to which specific area. Next, Mr. Thomas So. Thank you, Chairman. Basically, this bill is authorized by the central authority. By the form of lease, this port will be given to Hong Kong for governing. First of all, I would like to clarify, as legal advisor has explained, in 2 you mentioned about the Standing Committee of the National People's Congress. It has stipulated the Hong Kong Port area and related extended area. And in 2 bracket C, it says that the specific coordinates and area are to be determined by the State Council. In 3, it mentioned that the State Council has already determined the specific coordinates and area, but we failed to look at the specific area. In Clause 3, Schedule 1, everything is included. I just wish to confirm one thing. Here it mentions that the State Council had already determined the specific coordinates and area. Are you referring to the Schedule 1 to this bill? Thank you. Deputy PS. Thank you for your question. It is correct. In the official reply of the State Council, it mentioned about the specific coordinates and area, and they are included in Schedule 1 of this bill. Thank you. Next, Mr. Webster. Thank you, Chairman. I have a question regarding the related extended area. Surely there are schedules and coordinates that are included in case, for certain reasons, some fine-tunings will be required in the future. Do we have to amend the legislature, or does it involve the subsidiary legislature? Thank you for your question. When we set out Schedule 1, the content are being coordinated by both the Shenzhen and Hong Kong government. It is very detailed, containing a lot of charts. Both governments are meticulous in setting out the coordinates, and it is also being confirmed by the State Council. In case there is any changes required, amendment at this council will be required. Next, Mr. Andrew Lam. Concerning the terms of the lease, as mentioned, this bill is actually very similar to that of the Shenzhen Port bill in terms of its structure and content. So in terms of lease, if you look at the Shenzhen Bay Port bill, it stipulates about the handling of the lease. However, in this bill, they only mention that it will be arranged through lease. It did not stipulate with whom is it going to sign the lease, etc. I am not just focusing on the discrepancies. In the absence of these kind of specific content, Will there be any issues legally speaking? Thank you, Chairman. I believe that these questions should be covered in the previous section. During clause-by-clause scrutiny, I want to see if the administration have anything to add. Thank you for your question. The focus of this bill is to apply Hong Kong jurisdiction at the Hong Kong Port Area Bill. This is the parameters of our provisions, and the handling would be the same as that of the Shenzhen Bay Bill. As for the lease, we will sign further agreements. Since we have a jurisdiction at the Hong Kong port area, we will be having the right to sign the lease, but it will not be reflected in the bill. Mr. Lee Chen-kang, I want to confirm something. Both the administration and members are using the terms of lease. Should it be an authorization and not a lease agreement? Ms. Choi, once again, it is a reflection of the wordings of the authorization of the Standing Committee of NPC. First of all, we are authorized to exercise jurisdiction in the Hong Kong port area. This is concerning the jurisdiction, and the arrangement of the lease is an exercise of the jurisdiction as well. So the Hong Kong side will sign a lease agreement with the Shenzhen side. So these are two separate issues under the same authorization. So this is included in the authorization. Correct. Ms. Carmen Khan, Chairman, I would like to ask about the preamble. Not all legislation include a preamble. Can the administration explain why are we incorporating the preamble into this bill? Is it to stimulate the steps before we come up this bill? That is the authorization of NPCSC, and then the official reply of the State Council, and then the legal legislation, etc. I believe that the preamble is part of the legislation, but it is not legally binding. Is it correct? Responding to your question, the Hong Kong Port Area Bill is handled in the same manner as the Shenzhen Bay Port Bill. Preamble is included in both bills because they are both co-location. So of course there will be authorization of NPCSC as well as a official reply from the State Council, and then there will be legal legislation. So that is to confirm the jurisdiction of both Hong Kong and Hong Kong courts, and the preamble is part of the legislature. That is part of the bill. Please continue. Thank you, Chairman. This bill can be separated into 6 parts and with 4 schedules. I would explain the related schedules. In Part 1, short title and commencement. That is Hong Kong Port Area Bill. It will comes into operation on the 31st July 2026, and that is the date set out in the official reply of the State Council. 2. Interpretation. In Mr. Arabian has a question concerning Clause 1. Thank you, Chairman. In Clause 1, it says that the ordinance comes into operation on the 31st of July 2026. Does it refer that to the power of law enforcement even before the port comes into operation? Correct. Since the 31st of July 2026, that area will be applying Hong Kong laws. So the law enforcement from Hong Kong is confirmed to enforce the law there. Mr. Wu Yingpang, according to your clarifications, I understand that this bill will come into operation before the commencement of the port, so there will be law governing over the area before the operation of port, and I believe it is necessary. I don't have issues with that. I just hope that the gap in between would be as short as possible. I just wish to ask, when is the estimate commencement date? I hope that it should be before the 1st of October, so that will be sufficient time for all parties to be familiar with the pedestrian flow during the National Day. This concerns policy level, and the Secretary has already responded to it for 4 times in the first section. Ms. Choi, allow me to supplement. The ordinance will come into operation on the 31st July 2026. From this till the operation of the port, we are still in need of the legal rights that are being set out in this bill, including the roads as well as the licenses, including the license of the engineers, because there might be construction work required in the Hong Kong port area. Can Hong Kong engineers operate there? So if the ordinance come into operation sooner, it will be very helpful to us. I will explain further as we come to those clauses. Clause 2. Clause 2, interpretation. The interpretation here is very similar to the Shenzhen Bay Hong Kong Port Area Bill. I would like to highlight a few points. For the Shenzhen Bay Hong Kong Port Area Bill, it was passed in 2007. In the past 2 decades, DOJ has amended its drafting so that the reading of the bill would be of higher clarity. For example, in the Shenzhen Bay Bill, we will put definitions for existing as well as court order. So for the Shenzhen Bay Bill, you have to read both interpretations in order to understand the joint term that is existing court order. However, in the past 2 decades, we have improved our legal drafting. Therefore, we are stipulating the meaning or the interpretation of existing court order, and that is the court order that comes into effect on or before the 31st of July 2026. Just now, Mr. Fogg and legal advisor have asked about the terminology Hong Kong port area, because the NPC have authorized us to use the term Huanggang port, Hong Kong port area, and related extended area. In the bill, we will define that it is all called Hong Kong port area. It means the area declared as Hong Kong port area, and related extended areas by Section 3. When I go to Section 3, I will brief members further. See if members have any questions. Mr. Chen Pui-Lang. Thank you, Chairman. I have a question concerning regulatory body. It says it means a person that regulates standards of competence or service within a profession, trade, or business. By business, are you talking about a natural person or a legal entity? Well, because it is an interpretation to the term regulatory body, but then it is referring to a person. We are referring to the body and its personnel. You may not understand the practical use by just looking at the interpretation. Actually, it is related to Schedule 3. As we go to Schedule 3, I will explain it further so that members would be able to understand it. Legal advisor. Allow me to add, if necessary, the DOJ can supplement as well. According to Chapter 1 of Hong Kong law, there is a definition. Basically, when it is referring to a person in Hong Kong legislature, it covers both natural person and a legal entity. DOJ, anything to add? Thank you, Chairman. Confirm what the legal advisor mentioned. The interpretation of person in Chapter 1, Section 3 of Hong Kong legislation is applicable here as well. Ms. Carmen Khan? If I compare the interpretation with the Shenzhen Bay Bill, we did not define the territory. In clause 3, there is mentioning of territory. Can you please explain? In the Shenzhen Bay Bill, it says it include both the area in air and on land. Do we not require such definitions here? As for the preamble is part of this bill. Its existence helps us to explain the bill, but it is not legally binding. I hope that the legal advisor or DOJ can confirm on this. Allow me to respond to the first question regarding the area. In the Shenzhen Bay Bill, there is related definitions, but it is not found here. When we look at the interpretation required in this bill, we have to understand the drafting process of this bill. In Schedule 1, we meticulously include all the coordinates as well as area. Even in the area on the connected bridge, we have already defined certain meters above the bridge is regarded as the controlled area of us. These are all being spelled out in the schedules. Therefore, I believe that it should not require any interpretation in this section. Legal advisor, anything you want to add regarding the preamble? Chairman, allow me to respond first. DOJ's representative is welcome to respond. From the point of view of the drafting of the bill, as the administration has mentioned, preamble is part of the bill. During the process of scrutiny, as we resume second reading, preamble will be part of our scrutinization and it has to be included in the bill. Therefore, I would not say that the preamble is not legally binding because it is part of the law. However, as Ms. Khan has rightfully put it, not every bill comes with a preamble. Preamble will be included if certain constitutional background or certain background needs to be mentioned in that bill so that the readers and the users can be aware of the context, we will put a preamble in that bill. And that is exactly the purpose of the preamble here. We are spelling out the constitutional background to this bill for the readers. For the interpretation of the bill, we have to refer to the interpretative clause of the bill so that we can understand the operation of the bills according to the terminologies. Thank you.
Any comments from DOJ? From the Senior Commissioner from the DOJ. Well, the drafting department had instructions mentioning the use of preambles. As Ms. Carmen Chan put it, preambles are very rare in Hong Kong laws, and they're only available to clarify facts or give background information. And the use of preambles is to assist in interpretation of the legal background of the clauses. But if the clauses are already clear, preambles are not necessary for interpretation. Thank you. Mr. William Pang. I have a question on interpretation regarding the definition of public officers. And this is for Clause 1 of the third schedule. Apart from officers, and we have this definition of public institutions. Why there is no definition for that? Do we have to draw reference from other laws? In drafting the interpretation, we considered whether this is a clear in the law, so we draw reference from the interpretations in the Shenzhen Bay port, and we believe that the interpretations are necessary and sufficient. Ms. Zhou Fei Chen, I have a similar question as to that of Mr. Wu Yinpeng. In the anti-bribery ordinance of official institutions, public institutions are included. Is it true that this doesn't apply to the Huanggang Port Bill, and in the bribery ordinance, public institutions are referred to? It doesn't make it clear whether this is the officers of the Shenzhen of the Hong Kong SAR government. So I understand that we draw reference from the Shenzhen Bay Port Ordinance. I believe we need to avoid discrepancy when we apply this ordinance. Thank you, Chair, and thank you to the member for the question. Regarding the definition of public officers, the member rightly put it, public officers mean a person holding an office of emolument under the government, whether the office is permanent or temporary. So we wanted to make it clear that it includes the offices nominated by the SAR government according to the Basic Law, and any principal official of the government is included. This definition refers to Chapter 591 regarding the Shenzhen Bay Port. We try to keep the consistency. That's why we use the same definition. Ms. Chen, and in follow-up, well, just to clarify, if we're talking about public institutions, are they including the public officers in the new Huanggang Port area bill? I know consistency is necessary, but when the law applies in the port, public officers, are they also included in the catch-all term of public institutions? Thank you, Chair. The definition of public institutions is made in Clause 3 of the first part. Well, I can read it out. Public institutions in Clause 3, Part 1 includes Executive Council, Legislative Council, District Councils, and other government departments. So public institutions include the officers in these institutions as aforementioned. The concern about lack of definition for public institutions, we referred to other ordinances, including Cap 1, interpretation and general clause. If they're already clear, we don't have to repeat the definitions in every ordinance. This is a common phenomenon in drafting laws. Any further questions on Clause 1? If not, we can proceed to Clause 3. In the second part, Hong Kong Port Area and application of laws of Hong Kong. Clause 3 is Declaration of Hong Kong Port Area. Clause 3, may I ask the members to refer to Schedule 1 regarding Hong Kong Port Area and related extended areas. In Schedule 1, there are coordinates and maps and charts, and the Part 1 is a description of areas of the Huanggang Port building, and Part 2 is a Shenzhen section of Lo Ma Chou Bridge and connecting roads, and Part 3 is the plans and maps. These are all the Hong Kong port area and related extended areas. According to the MPC Standing Committee, this is a Hong Kong port area and extended area. So we need to refer to clause 3, and then therefore the descriptions in part 1 and maps and plans in schedule 1. So with them together, we will understand the application scope of the jurisdiction in this bill. Mr. Thomas Sowell.
聽到嗎？
聽到啦。
OK。
I have a question. Some members asked this question. Hong Kong Port Area, Clause 3 and Schedule 1 are very specific. I'd like to ask a question regarding the spaces. I believe this is a key question because I noticed that the bridge was mentioned. This is in part 3. We are talking about vertical limit of the Lo Ma Chau Bridge and connecting roads. So it's a surface area and a height of 6.6 meters. So in this space, Hong Kong laws will apply. So I have a question. Given that situation, have we considered the possibility of low-altitude economy activities in the future? That's the first question. And secondly, in Shenzhen Bayport, it was a vertical limit of 160 meters, but why is here only 6.6 meters? Thank you. Thank you to the member for the question. Yes, in Division 3, which is regarding the vertical limit on the bridge, there will be lamps, lamp posts, and there will be signboards. If Hong Kong laws apply, these facilities will follow Hong Kong laws. Why is it that Hong Kong laws would not no longer apply with a height of 6.6 meters or above? We have discussed this with the mainland authorities. The spaces belong to the mainland, so we could not change the purpose of them. We only use part of the space for the purpose of a Hong Kong port. So this is why in Huanggang port, we only need a space of 6.6 meters for the operation of the Hong Kong port. Next, Mr. Chen Yong. In Clause 6, subsection 2, are there any examples for a dealing after 31st July 2026? Is it possible that we will have a dealing without the land right? Mr. Chen, sorry, we are only on Clause 3, but I'm sure you can give a pre-warning to the Deputy Secretary of your question. Well, Deputy Secretary, well, I think you can go through the clauses from Clause 3 to Clause 6 before answering the questions. Okay, I will go through Clause 4 to 6 before I take any questions. Clause 4 is regarding Hong Kong Port Area as a closed area. In the preamble, it stated that Hong Kong Port will be managed as a closed area. So in Clause 4, it states very clear that for purposes of the public order ordinance and any further enactment that applies to the closed area, the Hong Kong Port Area is a closed area. Clause 5, application of laws of Hong Kong in Hong Kong Port Area. This is frequently mentioned. 5.1 states that except insofar as otherwise provided by an enactment enacted or made on or after 31st July 2026, the laws of Hong Kong apply in the Hong Kong Port Area. And 5.2, for the purposes of applying the laws of Hong Kong in the Hong Kong Port Area, the Hong Kong Port Area is to be regarded as an area lying with Hong Kong. In other clauses, the idea of this area will appear again, And in 5.3 again, if an enactment applies only to a specific area in Hong Kong, for example, in case of taxis, taxis in new territories can only operate in new territories. What about Huanggang port area? Huanggang port area is considered as a part of new territories or within New Kowloon, or simply put in NT. So if some enactment apply only to a specific area in Hong Kong, then Huanggang port area belongs to a new territory. And 6, land in Hong Kong port area to be regarded as government land. As we said, this area is acquired by a way of lease. So subsection 2 involves what Mr. Chen mentioned. Given that it's acquired by way of a lease, we enjoy some lease rates. For example, the employees will have a canteen, and the canteen needs operators. Although we have acquired the use rates through a lease, 6.2 granted that an operator of a canteen can sign an agreement, and the agreement signed will also be subject to this ordinance. That means the agreement signed will be under the laws of Hong Kong. That's what it means. So I can stop here and see if we have any further questions from members. Mr. Chen Yong, any follow-up questions? I understand. I asked the question because there were no such clauses regarding the West Kowloon train station. Next, Mr. Webster. Thank you, Chair. I have a question regarding Clause 5, regarding the application of laws of Hong Kong in the Hong Kong port area. Let's assume if we were to do something in Hong Kong port area, then I would have to pay taxes under Hong Kong laws. This is the first issue. As we said, there will be a clear line. I would not imagine that some dealings would be done spanning across the border, but if there were some deeds and transfer of documents, then stamp duty will be paid in Hong Kong. But what if the dealing is made in a point where it spans over Hong Kong and the mainland? How would it be handled? Thank you. This bill states very clear from where onwards Hong Kong laws would start to apply. I will mention this in Part 4 as well. Simply put, any documents, unless otherwise specified, will be will see that Hong Kong laws apply. For example, if the agreement is signed in the Hong Kong port area, then Hong Kong laws will apply. Mr. Wu Yingpeng. Thank you, Chair. I have a question also on 5.1. As you know, the Northern Metropolis Bill under scrutiny is relevant. I understand that 5.1 includes the Northern Metropolis Bill. But the Northern Metropolis Bill will also stipulate the area for Hong Kong Metropolis, Northern Metropolis, and it will include the port area, but it doesn't specify Huanggang port area, because when the Northern Metropolis Bill was drafted, Huanggang port area did not exist in legal matters. When the bill has been passed, will the government amend the Northern Metropolis Bill in order to add the wording of a Hong Kong port area? Because in the future, we need to pass the Northern Metropolis Bill to facilitate cross-border activities. So I believe Hong Kong port area will need to be added. Thank you, Chair. Thank you, Member, for the question. Let me stress that the highlight of Clause 5.1 is about which laws apply in this port area. That means the enactment made on or after 31st July 2026, the laws of Hong Kong will apply in the Hong Kong port area. As you mentioned, the North Metropolis Bill is under scrutiny, but it has its own scope according to its needs. So the applicable scope will need to be subject to the actual needs, whether Hong Kong port area will be included. We understand that the relevant departments believed that it was not necessary to include Hong Kong port area. Next, Ms. Carmen Can. Thank you, Chair. I have a similar question to that of Mr. Wu. But after hearing the response from the Deputy Secretary, I have a follow-up question. In Clause 5, except insofar as otherwise provided by an enactment enacted, or in case of subsidiary legislation made or on after 31st July 2026, I don't see any examples as exceptions, but we're not sure whether there will be any enactment ordinances or subsidiary legislation. We're not sure if there are exceptions in the future. Otherwise, Hong Kong laws will apply in the Hong Kong port area. Can you confirm that at this point, at this time, there are no exceptional cases? This is my first question. My second question is, by way of declaration, is it possible that, according to Clause 3, is it possible that we can, by the way of a declaration, if we can declare the coordinates and delineations in the official reply from the State Council, if we can delineate according to what is specified in Schedule 1, 2, and 3, so they can be regarded as the Hong Kong port area.
Deputy Secretary, as we have to make clear of different circumstances and scenarios in the future, at the moment, even when we talk about Clause 5.1, we're talking about an enactment to be made on July 31st, 2026, because when there are to be statutory provisions to not include Hong Kong port area, we need to allow a flexibility to do so. As to using the term declaration, it is the same as how we used it in Shenzhen Bay Port. Let me see if there is any supplement from the legal advisor. Mr. White. Well, yes, this is the same as the Shenzhen Bay Port. In Cap 591, we also use the term declare. Chairman. Well, other than just saying that you follow the Shenzhen Bay Port, because not everyone has participated in the scrutiny of the Shenzhen Bay Port Bill, how about you let us know about the legal effect by using the term declaration? That is the core of my question. Before the administration takes this question, Ms. Khan, in general, I appreciate that the DOJ uses Cap 591 as an example. Currently, when we need to make any amendments, then it would come back to the LegCo. This is actually a new bill. As to how we declare or amend it, this would be something to be done in the future. I believe it is quite clear at the moment, but I can seek the advice of the legal advisor. Thank you, Chairman. I'll say a few words and see whether there is any supplementary information from the administration. Ms. Khan can understand it this way. The preamble is a decision made by the NPC to authorize the Hong Kong Special Administrative Region to exercise jurisdiction over Huanggang Port. This is the basic foundation of our bill. The official reply of the State Council determines the specific coordinates and area of the Huanggang Port area. What we are doing right now is to implement the decision made by the MPC through local legislation so that we'll be able to apply the laws of Hong Kong to the Hong Kong port area. Through Clause 3 of the bill, to declare Hong Kong port area is defined clearly together with Schedule 1 of Part 1. The maps and coordinates of Schedule 1 are those approved by the State Council. Our local legislation only allows us to implement the decision made by the NPC. Thank you, Chairman. Thank you, Legal Advisor. The Declaration of Hong Kong Port Area is the area approved by the State Council. No amendments have been made to that area. Yeah, I just want to clarify that the term declaration is suitable. Thank you. Mr. Candy, I would like to refer to Clause 6 on the right to use the Hong Kong port area. In the preamble, it is stated that the right of use is through lease of land. Can we understand that other than being operated by the Hong Kong government, it can also be further leased to retail? Can this right be exercised as well? Deputy Secretary, thank you. We lease the land, but this is part of Hong Kong land, and therefore the government has the right to use it. We have to sign contracts with franchises or other retail to adopt Hong Kong laws after the commissioning of the Huanggang port area. Therefore, we have made it clear that areas within the Huanggang port are considered as land within the Hong Kong area. We need this clause to assist us in understanding the definition and also in future operations. Mr. Augustine Wong, I want to try to understand it more. So can we explain it through subleasing it to other tenants? Or let's say we lease a land till 2047 and then we would then lease it out to other shops, so it's more like a subtenant. Can we try to understand it with this analogy? So it's just like the block grant lease when the UK took over Hong Kong. So this is similar to that. We can sublease it out, but no terms and conditions were stated. There's just a time limit. Yes. Although it sort of feels like a sublease, the retail party actually signs a contract with the Hong Kong government. There's no middleman in between. it actually is a contract signed with the Hong Kong SAR government. We can use the canteen as an example. The canteen will only sign the contract with the Hong Kong government, and that contract will be interpreted under Hong Kong law. Please continue, Deputy Secretary. Thank you. Clause 7, jurisdiction of courts. A court has jurisdiction to hear and determine any cause or matter, whether civil or criminal, arising from the operation of this ordinance in like manner as it has jurisdiction as regards the operation of the laws of Hong Kong in Hong Kong. Please continue. Part 3, pre-existing rights and obligations. Please hold on. Mr. Wu Yingpeng. Well, yes, I do have a question on the jurisdiction of courts, Clause 7. So this also draws reference from the Shenzhen Bay Port Bill ordinance. But it says that without affecting Clause 1 in principle. But we differ in a little bit that we said without limiting subsection 1. Why is there such a difference? Thank you. Without limiting subsection is actually a bit new. The intention remains the same with the Shenzhen Bay Port. Although we are now referring only to the Chinese version, due to the drafting of the bill, the latest version of the draft already reflects that the old way of saying is not applicable, and so we can already see this reflected in the English version as well. Deputy Secretary, Part 3. Part 3 on pre-existing rights and obligations. Which refers to rights and obligations before July 31st, 2026. So pre-existing rights or pre-existing obligations are not affected. So we have to safeguard the rights. However, the Secretary has mentioned previously that when the government is exercising its authorization, we do need continuation. Therefore, in Section 9 and 10, we stated clearly when the territorial limit of certain pre-existing rights and pre-existing obligations can be extended. Mr. Yu Ming. Thank you, Chair. Is 5.5 bracket 1 and 5 bracket 2 the same? What is the difference? Do you need to include clause 5 into this? Thank you for your question. As clause 8 refers to territorial limit, we believe that if we can use Section 5.2, which is for the purposes of applying the laws of Hong Kong and the Hong Kong port area, that is more suitable. Mr. Webster, thank you. I would like to look at clauses 8 and 9 together. The immigration ordinance will include ordinary ordinances. I hope I'm understanding this correctly. We're extending the right, but we're applying Hong Kong law. Let's say when a person is there for a long term, then we will treat that person as an ordinary resident. I'm not sure whether I'm understanding this correctly. Oh, this is a concrete example. So you're referring to the Hong Kong port area, and that is to be used for port purposes. Let me try to explain this further. Clause 9 can be seen together with Schedule 2 and 3. If the chairman does not mind, how about I go through clause 9 together with schedule 2 so as to better help you understand the clause. Well, unless we fall into section 9 or 10, then the territorial limit will not be affected. Clause 9 refers to rights and obligations. If they fall into schedule 2, and still has legal effect as of July 1st, 2026. The territorial limit will still extend to include the Hong Kong port area. Let me give you a simple example. Let's say we have already set out a warrant before the Hong Kong port area comes into effect. Well, let's say the criminal has gone into Hong Kong port area. Can you still arrest that person? The simple answer is yes. Schedule 2 also lists out some licenses. License may already be delegated to doctors or engineers. When the Huanggang port area is commissioned, will the license of a doctor extend to the port area? Well, the doctor will still be able to help patients in that area, and of course engineers will also be permitted to work in the port area. Well, it is a border point. Clause 5 states clearly that Hong Kong port area uses Hong Kong law. Simply put, the laws of Hong Kong apply in the Hong Kong port area. Let me follow up on the question. The Deputy Secretary has been clear in her answer, but there are many professions that require the resident to be stationed or domiciled in Hong Kong in the long term. Let's say, yes, a doctor has a license. My question is on ordinary residents. This may be a requirement for license renewal for some of the professions in Hong Kong. When the bill comes into effect, then the laws of Hong Kong will apply in the Hong Kong port area. And if you ask whether that area is considered as Hong Kong, then yes, it is within Hong Kong. All right, let's move on. Clause 10. Thank you, Chairman. Well, Clause 9 refers to rights and obligations, and Clause 10 will talk about territorial limit of certain rights and obligations conferred or imposed by pre-existing court orders. Let's say an arrest warrant has been made, and the court will be able to issue an order for such a warrant, which may have been issued before July 31st of 2026. And we can look at this together with Part 2 of Schedule 4 to confirm whether these rights and obligations imposed by the pre-existing court orders can be extended. Ms. Carmen Can. Thank you, Chairman. Part 3 consists of clauses 8, 9, and 10. My understanding of Part 3 affects not only the public bodies, pre-existing rights and obligations. That means those before July 31st, 2026. Because of this bill will have the territorial limit of certain rights and obligations extended. Therefore, for Clause 9, you will need to look at the rights and obligations included in Schedule 2. And do we have to refer to page C3779, Schedule 2? Well, Chinese version is C3778. So here you can see some pre-existing rights or obligations, such as deportation orders, removal orders, or orders made due to health reasons to prohibit a person from leaving Hong Kong, and then also licenses, permit, certification. I'm sure that, well, that was the example of the doctor. So for those in Schedule 2 and in Clause 9, then those pre-existing rights and obligations will be extended. However, for those not listed out in Schedule 2, then those will not be included. I understand the part on Clause 10. I'm just unclear about Clause 9. Thank you. Your understanding is correct. We're talking about pre-existing rights and pre-existing obligations. A contract signed before the date would not be affected unless otherwise. We want to ensure that court orders could continue to be effective, and therefore we have stated that if you fall into the right or obligation under clauses 9 and 10, then it would continue to become effective.
冇問題，我哋
If there is no further question, we can move on. Thank you, Chairman. Part 3 refers to pre-existing rights and obligations. For Part 4, after the establishment of Hong Kong Port Area, there are certain future rights, obligations, documents, and court order. In Part 4, there will be certain documents and court orders, and there has to be certain applicable territorial limits as well. The key message is, apart from some explicit or written contradictions, otherwise, whenever Hong Kong is mentioned, its territorial limits shall be explained as Hong Kong Port Area. In Clause 11, there is a clarification. That is, if a future right has spelled out that it is not including Hong Kong port area, then we cannot just rely on Section 5 bracket 2 and understand it as having an effect of extending the territorial limit of the right or obligation to include Hong Kong port area, because we have to respect those who spell out the exclusion of Hong Kong port area. So although we are regarding Hong Kong port area as part of Hong Kong, however, in future enactment, if there is stipulations excluding Hong Kong port area, such flexibility would be allowed. Can you cite an example so that we can understand the effect of this clause? Since it is part of Hong Kong, then you said unless otherwise stated in certain documents or court orders, then it will not be applicable. What are the possible circumstances? It will be difficult to cite legal examples. Let's talk about documents. For instance, intellectual property rights. If I'm a singer and I have the copyrights to certain song, then maybe in Chinese mainland the copyright will be handled differently. Then in the document, it has mentioned that in Hong Kong port area, although it is legally regarded as Hong Kong, but the documents regarded as the jurisdiction of Chinese mainland, then we have to respect the consensus of the two parties signing this document. Therefore, unless there is a explicit stipulation regarding the inclusion or exclusion of Hong Kong port area, for example, if it has stipulated that in Hong Kong port area, the copyrights will be charged song by song, and in Chinese mainland it will be charged as a whole, then we will perceive it as two separate exercise of rights. Any examples about this contract out effect? Since it is part of Hong Kong, but you can exclude the application of certain laws in that area. Is it possible? If you are talking about contractual terms, if it involves personal injuries, you cannot exclude any personal liabilities. I just wonder, what are the scenarios that works? You are talking about IP, and I understand. How can the contract override the territorial power and control? I think it is not an exclusion of the territory. It is not that I am drafting a document and saying that we will not be applying Hong Kong laws in that particular area. That is not what I meant. Let's say I am a newspaper delivery man, and I might go into a agreement with you delivering newspaper in Hong Kong, but I would spell out that my service scope does not include Hong Kong port area. In this case, I cannot just rely on Section 5 bracket 2 and claim that I am entitled for such service since it is part of Hong Kong. Because my agreement with you can spell out that my newspaper delivery service does not include Hong Kong port area. This is the drafting of Clause 11. That is the limitations on operation of Section 5 bracket 2 in relation to future rights and future obligations. Although Clause 5 is already very explicit, but still, future documents can still stipulate terms that are different. And in Section 5 bracket 1, although Hong Kong laws are applicable in Hong Kong port area, however, if there are future enactments that stipulate another area, then you will have options to choose. In Clause 12 and 13, there will be further explanations in this regard. It is rather interesting. I have to learn about this. For contract laws, contracting party can choose to exclude certain binding rights because this is something concerning two parties. However, if I am stating that certain public law would not be applicable in this area, You're telling me that in Clause 1 we can exercise such right and its legal basis is Section 5 bracket 2. It seems to be quite a novel breakthrough. Well, I think newspaper delivery is not a very applicable example, but it helps me to think more clearly. Even if I am just delivering to Mongkok but not Yamate, it will be exercisable because it's just simple contract. For instance, if I'm just delivering Mook to Mongkok, but if I deliver it to Yamate, I cannot be held liable in case you experience diarrhea. Even within Hong Kong jurisdiction, it will not be allowed. Therefore, I can't understand if private right can override public right. If that is the case, it is a huge breakthrough. Thank you, Chairman. Allow me to supplement. Your understanding is accurate. In Clause 11, we are referring to rights and obligations that concerns contracts. Clause 11 does not exclude the exercise of does not refer to public rights. It is referring to contracts, that is private rights. Mr. Webster, thank you, Chairman. I want to further clarify about Section 5 bracket 2 and Clause 11 Section 2. When you mention Hong Kong, then theoretically speaking, it covers Hong Kong port area unless it is otherwise stipulated. I have to understand if it is correct. Then some extended thoughts, as Chairman has put it. Can private contracts override the law? We have to consider it further. If this bill is passed, then in the future, when we refer to Hong Kong, are we referring to Section 5 bracket 2 or Clause 1 Section 2? Thank you for your question. Unless otherwise stated. Otherwise, all the documents signed in the future, the territory would include Hong Kong port area. Clause 11 has one particular terminology, that is territorial limits. Does it include or not include Hong Kong port area? Upon the operation of this bill, then when we talk about Hong Kong, certainly it would include Hong Kong port area. However, if there is an enactment or there is a stipulation explaining that the area does not include Hong Kong port area, we have to respect that, and then we have to put in such provisions stating that it is allowed. Ms. Judy Chen, thank you, Chairman. I find it interesting. I wish to understand it further. The administration has responded that, well, let me cite an example. I think newspaper delivery is not a very good example. Well, as we know, there are a lot of cross-border insurance contracts nowadays. According to my previous understanding, if I sign an insurance policy in Hong Kong port area, if you claim that it is considered as signing in Hong Kong, then it will be considered as such. However, according to Clause 11, in the insurance contract, I stipulated that I am excluding the Hong Kong port area. Does it mean that I'm not signing the contract in Hong Kong? We always mention that we are referring to the Shenzhen Bay Port Bill, and I think they have similar provisions as well. Is there any practical examples that we can learn from the Shenzhen Bay Port? Thank you. Thank you, Chairman, and thank you, members' question. You understand it correctly. First of all, this provision is consistent with that of the Shenzhen Bay Port Bill. And we have not received any questions concerning the implementation of that bill. Since we are talking about the exercise of rights and obligations, we have to look at the territorial limits of them. In other words, we are looking at their applicable scope. It may not be referring to the application of Hong Kong law. Well, because as already mentioned, since it is part of Hong Kong, Hong Kong law will be applicable. Can you understand? I think you can understand. If there is no further question, let's move on. Clause 12. References to Hong Kong in future documents. If a future document contains a reference to Hong Kong to describe the territorial limit of a right or obligation, again, we are talking about territorial limits, then the territorial limit of the right or obligation is to be construed as including the Hong Kong port area. However, it can be displaced by a contrary intention, and it's not applicable to an enactment or a court order. For court order, we will take care of it in clause 13. Let me proceed because clause 13 has mentioned about future court orders. In clause 13, if a future court order contains a reference to Hong Kong to describe the territorial limit of a right or obligation conferred or imposed by the court order, unless there is a contrary intention, otherwise the territorial limit of that is to be construed as including Hong Kong port area. Legal advisor. Thank you, Chairman. Regarding clause 12 and 13, I would like to seek clarifications. We are aware that in clause 12 and 13, as Deputy Secretary has mentioned, in clause 13 section 2 and clause 13 section 2, there is a mentioning of a displacement by a contrary intention. In clause 12 section 2, it has mentioned that in clause 13 subsection 2, it said that the contrary intention has to be appearing from the court order. However, in clause 2 subsection 2, it did not mention about the appearing of contrary intention in future documents. Why is that so? Well, are you considering a certain contrary intention that may not appear in documents? However, for court order, it has to appear in court order. Is this the reason behind the discrepancies? Please explain to the members. Thank you. Thank you, Chairman. And thank you for your question, legal advisor. Your understanding is correct. In clause 12, we are referring to documents, which include written contracts and agreements. Under certain circumstances, apart from the written contract, the two contractual parties might have some collateral contracts. They may not be part of the document. They may be considered as certain materials that is supplementary to the explanation of the documents, including oral agreement. By contrary intention, we want to show that it is not restricted to the written documents. It also includes other oral agreements of the both parties. If there is a contrary intention, then we will respect that, so that subsection bracket 1 will be displaced. But court orders are different, because court order itself is a document. If a contrary intention appears from the court order, then Hong Kong port area will not be included. Otherwise, it will be covered. Legal advisor, any follow-up? No. Please move on. Part 5. Thank you, Chairman. Part 5, miscellaneous provisions. In clause 14, expiry of this ordinance. It is also mentioned in the authorization that is the 30th of June 2047. Also mentioned in the provision is that if it is terminated earlier or if it is renewed, then a notice published in the Gazette will serve the purpose of the announcement. In clause 14 bracket 3, we have mentioned that the notice published in the Gazette is not subsidiary legislation, which is exactly the same as the Shenzhen Bay Port. As time moves on, sometimes members would ask, is it part of the subsidiary legislation? And that is why we are spelling it out as we draft this bill. The notice published in the Gazette is not subsidiary legislation. The execution or the language or the intention is exactly the same as that of Shenzhen Bay Port. Legal advisor. Deputy Secretary has briefly touched upon that. I just wish to draw members' attention to it further. In clause 14, subsection 3, it's stipulated that under subsection 2A, the notice published in the Gazette is not subsidiary legislation. Would the Deputy Secretary further explain why isn't such Gazette notice part of subsidiary legislation? As mentioned, we are aware that in the Shenzhen Bay Port Hong Kong Port Area Bill, clause 14, there is no enactment as we can find in clause 14 subsection 3. As Deputy Secretary has mentioned, it is probably because of the changes in our drafting. That's why in the existing bill, there will be a discrepancy from that of the Shenzhen Bay Port Bill. I would like the Secretary to explain it further. Thank you for your question, Legal Advisor. Allow me to respond to the second question first. As you have mentioned, in the Shenzhen Bay Port Hong Kong Port Area Bill, there is no mentioning of clause 14 subsection 3. But the implementation is the same. We just want to follow the protocol of drafting of bill so that we can prevent further controversies. That's why we have spelled it out here. And that is, the notice published in the Gazette under subsection 2A is not subsidiary legislation. Allow me to touch on this first. Well, because we talk about the expiry of this ordinance, and it is a reflection of the authorization of the National People's Congress in clause 14 bracket 1, the date is also part of the authorization of NPC. Therefore, we believe that it is not part of subsidiary legislation.
Any supplementary comments from the DOJ? Just one point. The recent laws, when drafted, will contain similar clauses stating whether it's a subsidiary legislation. We believe Gazettal has two categories, legal notice and the other category, GN, gazetted in the administrative manner. So this clause makes it clear that this is not subsidiary legislation. Mr. Eric Yim, the legal advisor said exactly what I wanted to ask about. Mr. Andrew Lam, in 14.1, it states at the day on which the term of the lease of the right to use, and the other clause states differently. So in 2A, the right to use is separated from the lease, but in bracket 1, it's put together. I'd like to know behind what's rationale is behind the difference. Deputy Secretary. Thank you, Chairman. Thank you, Member, for the question. Well, in the Hong Kong port area, we acquired the right to use through a lease. This is mentioned in the authorization part. So 14.1 is regarding the lease term. But we use the right to use and the lease term differently. The right to use is acquired through the lease. That's why we have two terms in one subsection. Well, strictly speaking, after the expiry of the lease, the right to use will expire as well. There is no such situation where the right to use has expired, where the lease will be still available, or the other way around. Yes, both terms are consistent, but from a wording perspective, it's consistent with the authorization. So Hong Kong is authorized to use the land, and the right to use is conferred by the lease. So just for the record, this is just to clarify that my understanding is right. Ms. Carmen Kan, regarding subsection 1, compared with the Shenzhen Port bill, which states at 0000 hours or midnight. So here, are we also talking about midnight? This is my first question. Second question on subsection 2. If the right to use the port area is terminated earlier than the date, that means the contingency is made clear here, and the official reply from the State Council doesn't stipulate this specifically. Can you confirm that? And on subsection 3, I believe I have a similar question as the legal advisor. So the common understanding is that if you don't exclude the possibility that a notice might be a subsidiary legislation, then it may be construed as a subsidiary legislation. But as the DOJ says, we have LN and we have GM. Does it mean that the intention of Shenzhen Bayport Ordinance and this bill both determine that both bills are gazetted through the legislative means, through the administrative means? DOJ, please. Thank you, Carmen Kan, for the question. At the end of, as the English version states, means the midnight of 30th June. So if we take a look at the clauses again, if we state midnight, then there is a possibility that people will question whether it's the midnight for the previous day or the second day. So if we say at the end of the date, then it's perfectly clear. And for the difference between GN and LN, the 14th clause of the Shenzhen Bay Port Ordinance is the same as clause 14 here. It's not a subsidiary legislation. Mr. Chairman, I had another question on subsection 2. Deputy Secretary, please. Thank you, member, for the question. As when I answered the question from another member, I said for the second paragraph E in preamble, it states that Hong Kong government acquired the right to use through the lease. And the right to use and the term lease both appeared. So that's why in clause 14, when it comes to expiry of the ordinance, there is the termination of the right to use and there is termination of the lease. So both are stipulated clearly in this subsection. Please move on to the next clause in the clause 15. And this stipulates the transition arrangement. Apart from these Hong Kong Port Area Bill, some subsidiary legislations will be necessary. So that's why in clause 15, if this ordinance comes into operation after it is published in the Gazette, there will be a gap, and during which some subsidiary legislations will proceed. That's why they will be implemented through the negative vetting process, and after the council, these subsidiary legislations will be tabled in the Legislative Council. And in 15.2, it stipulates that the exercise of power under subsection 1 is not effective until the 31st of July 2026. Let's move on. In Part 6, we have related amendments. In Cap 1 Interpretation and General Clauses Ordinance, there will be some amendments, simply put, with the Hong Kong Port area. The Interpretation and General Clauses Ordinance, or Cap 1, will add the term Huanggang Port, Hong Kong Port area. And that means it's defined by Section 2.1 of the Huanggang Port, Hong Kong Port area. And there will be construction of power to make subsidiary legislation when new amendments were added. We will add, after 20A1, a clause that allows us to declare that this subsidiary legislation applies to Hong Kong Port area or not, or whether we can stipulates differently for this Hong Kong Port area. Now we will move to the schedules. Chairman, when we went through these clauses, we made a brief mention of the schedule because they were bundled together in our presentation on the clauses. Are there any further questions, Mr. Chan Siu Hong? For Schedule 1 onwards, this information displays the coordinates and delineation borders of the Huanggang Port building, and the coordinates were very clear. I have a question regarding Division 1 of Part 1 of Schedule 1. As for the building in different levels, there are X coordinates and Y coordinates, but vertically, do we have any coordinates for the vertical dimension, for example, 6.6 meters or 10 meters? As we have the vertical dimensions inside the building, do we have such coordinates around? In the building, everything is very clear because we're talking about the specific level or floor of the building. But if we exclude the ceiling, if we look at the surface of the building, facade of the building, and that's the area administered by Hong Kong government. So we can use X, Y, Z coordinates to define the three-dimensional space. So that means we don't have to define 6.6 meters for the space above the bridge, because there is no such thing as a physical ceiling at 6.6 meters. Of course, things will be very clear for every floor of the building because we're talking about inside the building. If there is division of labor and responsibilities, maybe there will be some facilities on the ceiling, so we need to define responsibilities. For example, fire services and air conditioners will be installed on the ceiling. If there are such projects, we need to define clear responsibilities. If there are responsibilities of the Hong Kong side, we need to have a clear division of labor. I think we need to have a clear division of labor between the Hong Kong and Shenzhen side. If there are hoses, rails on the ceiling, then it's the job of Hong Kong side, and these pipes are connected to some sort of pipeline network which connects Hong Kong and Shenzhen. If there is water leakage, then we need to look at where the water leakage happens. If it's in the Hong Kong side, then it's the responsibility of us. Mr. Andrew Lam. Mr. Chairman, regarding the coordinates, I believe the comparison is drawn between the Shenzhen Bay Port. This time, we used the coordinates from China Geodetic Coordinate System, Of course, if we are talking about Shenzhen Bay Port, then we use the coordinate system of Shenzhen. But when it comes to vertical dimension, Shenzhen Bay Port used the 1985 national system, but Huanggang Port uses 1985 coordinates system, and you can claim that these two systems are identical, but there are some differences. It's not that I don't accept the comparison, but this time, is there any specific reason behind the fact that we use this benchmark, not the previous system? Thank you. When we determined the coordinates, it was that Shenzhen and Hong Kong worked together. We worked out this system, and it was reviewed by the national government. So there's no need to worry because everything is clear. And in the mainland, they need to delineate an area for Hong Kong administration. So the descriptions, the systems, and benchmarks that were used were all included as part of the official reply from the State Council. Mr. Webster. Thank you, Chair. Coordinates and these maps are very clear. I have another question. We mentioned the dimension of 6.6 meters, but what about underground? For example, pipelines and pipe networks, etc. I believe this is similar to the previous question on the ceiling. From top to bottom, or if there is anything underground, they are included as well. Mr. Chan Puiliang, I have a question regarding the vertical coordinates. If a place exceeds the specified vertical limit, then the area above, does it apply to Hong Kong or Shenzhen? If it exceeds the height limit, then it's for the mainland. For example, if the drones pass by, if there are some problems, then it would be for the Shenzhen side to conduct law enforcement activities. Ms. Carmen Can. Mr. Chair, we're talking about the large amount of coordinates and maps. There are 198 pages. I understand that it's for the first time that we conduct this new model of a joint inspection. So probably we need to define the clear coordinates in every point in the custom clearance area. Is that true? Yes, that's one of the reasons. Another reason is that this port is structurally different from Shenzhen Bay Port because we're talking about a huge building with multiple floors, and which floor is the Shenzhen Port area and which floor is Hong Kong Port area. Every floor is different. That's why at every floor, starting from B4, B3, on every floor we have clear coordinates. This is different from Shenzhen Bay. In border crossing facilities, we have clear coordinates, but given the amount of data and given the fact that we have a multi-story building, we need a large amount of coordinates in the maps. That's why the amount of data is much more than the Shenzhen Bay Port. If there are no more questions, I will now invite the legal advisor to review the appropriateness of the drafting of English version. We haven't discovered any problems regarding the drafting of the English version of the bill. If there are no other views from the members, now we have completed clause by clause deliberation. And I'd like to ask if there are any members wishing to propose amendments. No. Secretary, does the Bureau wish to propose amendments regarding the bill? We don't have the intention to propose any amendments. Now we have completed the scrutiny of the bill. If there are no other views, the bill will be considered as ready for the second reading debate. Secretary regarding the arrangement for resumption of the second reading debate for the bill. Is there any suggestion? Chairman, members, on behalf of the SAR government, I would like to thank the Legislature again for your support to the bill on Hong Kong port area of Huanggang port. So we can proceed with this important work. I thank the Legislature for accepting our views. After the gazettal of the bill on the 14th of July 2026, thank you for arranging this meeting on the 15th of July. Thank you to the chairman of the House Committee, and thank you to the Legislative President for this special meeting so we can proceed with the scrutiny of the bill. And I thank the chairman and all the members for engaging in the discussion, which lasted for 4 hours, and thank you for the questions. So me and my team can give elaboration on the clauses so we can provide clear explanation on the clauses, and thank you to the Secretariat. The Huanggang port is an important step for Hong Kong to dovetail with the national development and facilitate the connectivity in the Greater Bay Area. And Huanggang port is a major livelihood project. We believe with the early opening of the port, which is the common goal of the two governments and two peoples, so residents can move across the border smoothly. As I said in the opening, the NPC Standing Committee on 26 June authorized Hong Kong SAR to exercise jurisdiction on the Hong Kong port area and extended area. And also on the 8th of July, there was an official reply from the State Council that the port area will be commissioned on the 31st of July 2026 to make sure that the measures are implemented. The government is responsible for completing local legislative process before 31st of July. And apart from the early legislation of this bill, we also need to make arrangement and make subsidiary legislations for the operation of the port. And this subsidiary legislations will need to come into effect before the 31st of July. And these legislative proposals have draw reference from the collocation custom arrangement in the Shenzhen Bay, and so you're very familiar with that. And we also used caption 591 of Shenzhen Bay Port Hong Kong Port Area Ordinance. Shenzhen Bay Port has been in operation for 20 years, and the it's a very good example of the effective model of collocation of custom clearance. It's a very good reference. As for subsidiary legislation necessary, most of them are similar to those in Shenzhen Bay Port. For Legislature to review the whole legislative framework, we have already submitted the drafts of legislative legislation, and we have received some questions from the members already. The passing of the bill will create favorable condition. In this way, both Hong Kong and Shenzhen can start preparational work, for example, comprehensive operational test, public transportation test, and stress test for contingency plans on the road to make sure that the facilities can be operated smoothly. We can get ready as soon as possible so the Huanggang port can be open to the members of the public as soon as possible. The SAR government will keep in touch with the Shenzhen government, and with the principle safety and safe operation, we will declare relevant announcements. This is a very important milestone for the House Committee to complete the legislative process. At the meeting, there were no amendments to the bill. I thank the House Committee and all the members again for your support to this bill. As we have a very tight legislative schedule, I hope that the House Committee can support the logical in starting the secondary reading debate as soon as possible. I will send a letter to logical president and apply for a new special meeting to resume the secondary reading arrangement. We hope that we can receive the support from the House Committee. If we can pass the bill through the third reading on the 17th July 2026, we will gazette this bill, and then we will complete the legislative subsidiary legislation that's necessary, and we can make sure that the subsidiary legislation can come into effect on the day of convening commission in this port. We will keep in close touch with the electrical so we can work together to proceed with the collocation of customs in the Huanggang port.
Thank you. Do members have any other suggestions? If not, then we would unanimously support the suggestion of the Secretary, and we would ask the President to consider holding a council meeting tomorrow. As the Secretary said, he will make a request to the President to add in additional meetings after the meeting. I would like to thank members for their support and to join in today's scrutiny work. And during the clause-by-clause scrutiny, we have received 37 questions. I thank the Secretary and your team for your efficient cooperation and assistance, and express our gratitude to the Secretariat for their support. Agenda item 2, AOB. There is no AOB. The meeting is now adjourned. Thank you.